Good afternoon. My name is Mark Cedra. I'm a senior fellow here at CG, and it's my great pleasure to introduce today's noon lecture on the rule of law and justice development in post-conflict environments, a review of Bosnia, Afghanistan, Iraq, and Sudan. And our speaker, and we're very pleased to have her here today, is Jasteena Dhillon, who's here in the front row. Jasteena is one of those unsung Canadian heroes in a way. One of these aid workers, academics, policy analysts, and so on, who travel the world contributing their significant expertise to helping people, in the case of Jasteena, to reconstructing failed post-conflict fragile states and making a major contribution to development and international peace and security. Obviously, we know very well what our soldiers do in the field, and we celebrate that, rightly so. But I don't think always we do enough to celebrate the civilians, the Canadian civilians in the field, also putting their lives on the line and working very hard in promoting Canadian values and universal values, of course, of human rights, peace and security and development. So I'm very pleased that we have her here today to also pay tribute to some of the significant and important work that she's done. To say a few words about Jasteena, she's a visiting scholar at Harvard Law School, an affiliate fellow with Harvard's South Asia Initiative, and previously she was an associate fellow at Harvard's Kennedy School of Government. Now at Harvard, Jasteena does significant and deep research teaching and writing on justice and the rule of law, informal and formal justice systems in conflict, post-conflict, and transitional countries and regions. Perhaps most importantly is, as I've already alluded to, is Jasteena is in the field. She's not somebody who is doing this research solely from the comfort of Boston or, for that matter, Toronto or Waterloo. She has been and done extensive work in places like Afghanistan, Iraq, and Sudan. Very difficult places to do research and to implement projects. And she addresses and works on a very key and, in my view, under-researched issue, something that we've looked at here at CG and continue to do extensive work on, which is promoting the rule of law. In rebuilding failed and fragile states, it's not just a matter of rebuilding militaries, reestablishing governments, holding elections, but it's establishing a sense of justice, establishing institutions and structures that can provide justice and uphold the human security of local populations. Often this is the poor cousin of state-building projects, not given or allocated adequate resources. Another aspect of this that Jasteena looks at, which also I think is under-researched and under-resourced, is how do you work with traditional and informal structures in these environments. Whether in a place like Afghanistan, it's working through tribal structures, or it can be in other contexts working with community-level organizations and norms. Often when Western countries go into these environments, we assume we're dealing with a blank slate. That our goal and our purpose in these places is to create a Western-style state, irrespective of what existed before. Maybe even worse, that we view what existed before as anachronistic and in need of deconstruction. Well, this is a problem, because what we know from the limited research that has been done is that the only institutions that tend to be viewed as legitimate, that tend to be effective, in most of these post-conflict and developing contexts are those informal institutions, those traditional structures. So we can't ignore them or work around them. We have to work with them. And that's what Jasteena does. She looks at the interface between the state and the non-state. And I first encountered her, we met in Afghanistan. And she was working on what I still cite when I discuss this subject in front of whatever audience, most recently in front of a Canadian military audience, working with informal structures at the village level in parts of northern Afghanistan to look at how they can integrate human rights standards integrate some of the standards of the formal justice system and the Afghan constitution into these informal processes, and was an immensely successful project that she worked on with the Norwegian Refugee Council, which I think is an exemplar, not just for Afghanistan, but for other cases around the world. So she has done, as I've already alluded to several times, some quite innovative and groundbreaking work. Before I hand the floor to Jasteena to launch straight into this presentation, and I've set the bar very high here, is I'd like to recognize our MP here, Peter Braid, who's here. I'm very pleased that he's attending. He's now becoming a regular attendee at these events, and we're thrilled that you're able to make it. Thank you very much. So with that, Jasteena, would you come to the floor and give your presentation?
Thank you, Mark. Yes, you've raised the bar very high. So let me just see if I can get this here without slipping off. I brought books just in case I get lost. Typical Harvard. This is going to stay on throughout my talk, and then I have a couple of pictures afterwards. I thought rather than distract you with some of the really cool pictures I have from the actual work I've done, I'll bore you a bit first with my talk. So I'll start. Ladies and gentlemen, I'm very pleased to be here, and thanks to CG, Mark Sedra, and also Ramesh Thakur, who sort of made the connection between Mark and I, whom, yes, we had met in Afghanistan many years ago. And I'm honored to be here today to speak to you about a very challenging and, in my view, very controversial still issue. And it's really, Mark touched on his introduction, but it's really how the intervention of the international community into complex conflicts and development of post-conflict environments that involves attempts to, and I'm going to use different words to describe this because it's not yet clearly defined what we really mean to do when we get involved in development of rule of law. So forgive me for switching terms because it's still very much debated. To bolster and form what the foreign intervention should be in terms of rule of law and development. So bolster and form. We're still debating these issues. And because these terms are still debated and because there's politics attached to it, it really has become, again, as Mark alluded to, mired in what I call confusion and actually ineffectiveness. And what I'm really talking about is, as Mark again alluded to, the most, I think, crucial aspect of our intervention in post-conflict, which is looking at the rule of law, and I say that with quotation marks because it is a natural law term which we learn in law school and which we learn in a philosophical way, but has now become essentially a euphemistic term to describe our intervention to build courthouses, to do legal aid, to ensure that human rights are adhered to in post-conflict countries. So these are actually two different terms in my view, but to make it simple, we'll use rule of law in this lecture to mean our intervention in these countries. And it's the view of the international community, and I say that meaning this is the community of military, civilians, NGOs, and other now more private companies who get involved in some of the most difficult conflicts and transitional places like Afghanistan and Iraq. They view that securing rule of law and the development of judicial institutions are crucial, yet unclear as to how to create the situation to ensure they form a firm basis for confirming the legitimacy of these governing authorities. So by that I mean that when we go into these countries like Afghanistan, we do realize that certain things must be put in place, like a constitution. We realize that certain activities should take place in order to legitimize the government, like elections. And we somehow realize that adjudicative and reconciliatory mechanisms need to be put in place to maybe deal with past crimes or even ensure that people have access to justice. But it's this last part that we really don't understand how to implement in these various places. And we kind of leave it, again, poor cousin, we leave it to the end until it becomes an issue. And even when it becomes an issue, we descend into, well, it's actually the fault of this particular country, these people, this population, this particular political group, this ethnic group, who doesn't want to join this state and become a sort of a functioning member of this new state that's been created. We blame them. On June 24th, 2010, so just a few days ago, the Security Council released a report called the Update Report on Rule of Law. And its aim is really just to review what the United Nations Security Council, and through its connection with other bodies like the UN Secretariat and the General Assembly, have done in terms of looking at rule of law in their policies and in their interventions. To me, that review, that 8-page paper, really reflected that there still is a debate among Security Council members, among UN bodies, and among the larger international community as to what the international community's will and capacity is to develop rule of law in these countries and regions. And what they did do is focus on, in this Security Council report, countries and regions that descend into conflict, that have a breakdown of law and order, that destroys or inhibits the functioning of the judicial and political institutions, such that they cannot address violations and breaches of human rights and humanitarian law. So we know what we're talking about according to the UN. We know we're talking about places which have nothing to do, no institutions in place to deal with what are some of the most gross violations that could occur. Having said that, as Mark alluded to in the introduction, I've also dealt with places where not only that happens, but everyday justice, everyday access to justice for everyday problems, dealing from theft to smaller criminal activities, also isn't dealt with in countries like this. So, you know, human rights violations aside, people can't go to their local community welfare office and be able to make a complaint about a government official. So there's everything breaks down. Now, to speak shortly what I mean in terms of rule of law in this context, as I said, as a trained lawyer, you know, what rule of law means versus as an experienced legal practitioner, what rule of law means, I've learned, are two totally different things. The phrase rule of law, as it appears in the literature on natural law, and as I learned academically, is hugely different in its appearance and its implementation than what I've seen in post-conflict settings. In fact, to me, there's a huge disconnect between its essence and its application. And actually, I think, and so this is like leading into my research and what I sort of aim to write about, I actually think this disconnect leads to our involvement in the development of, and maybe this is a bit of a harsh word, useless institutions, and actually misapplication of laws to these fledgling states. So we don't really know what we mean. We use a term like rule of law, which carries with it a lot of importance and relevance, of course, philosophically, but then we try and filter it through programs which get nowhere close to really implementing this all the philosophical values that underlie rule of law. And so when a local Afghan sees an institution being built, a court, they know they're going there to make a complaint, to file a case. To us, to the international community, that means there's rule of law. But it doesn't have anything to do with whether the quality of law is being applied, the quality of the people implementing those laws, the understanding how that law connects with the larger international legal body of knowledge which is developing related to conflict of states, so conflict within states. So there's a huge disconnect, and I think that leads to a huge, as I said, misapplication. So now it's euphemistic. It's a euphemistic word. And those of us in the business know what it means. So it's not like we're all walking around doing useless stuff. I mean, we really know what it means. It's just that we aren't spending enough time and money on researching exactly what elements of this philosophical term, rule of law, can be used in the field in post-conflict states. And I go back, when I think about this and research this, to people like Foucault, and I'll talk a little bit later about some of the legal development theorists that are coming out, looking at how law and development, how legal issues are being dealt with in post-conflict states. But when I look at the work I've done in Afghanistan, even in Sudan, to some extent in Iraq, and differently in Bosnia, which I'll talk about, I realized that we didn't really think about how those countries' historical legal developments, the concept of rule of law, and the situation post-conflict all needed to fit together in order to develop a comprehensive judicial system which is accountable and accessible to everybody. It's a lot of work. It's too much. And the time period that we stay in these countries in order to stabilize them and develop them to some extent, although we're getting less and less interested in staying longer in these countries, we don't have enough time to do that. So that, then leads to probably what we can discuss talk about in questions and discussion is, where do we stop and how far do we go in these countries, and what does that mean to us as countries who come with a lot of tools and resources and will and goodwill in terms of our commitment to other countries. So just to talk briefly about the history of the United Nations in terms of raising the issue of rule of law. So all of this started talking about why rule of law is important, why the United Nations, hence the international community, needs to be even interested in the rule of law. Started in October 2004. I mean, there's been discussions before, but these are recorded sort of points. There was a debate that took place in the Security Council called Justice and Rule of Law in October 2004, preceded by two earlier debates held only at the ministerial level in 2003, which were very broad. And in 2004, the Security Council accepted recommendations that focused on ensuring that the rule of law was implemented in conflict and post-conflict situations so as to ensure the building of the confidence of populations affected by the conflict. I'm just quoting here. And the aim was to see how the Council could ensure these elements were incorporated into its operations. And these debates took place under the presidency of the United Kingdom, and later, a couple of years later, another debate took place under the Danish presidency of the Security Council called Strengthening International Law, Rule of Law and Maintenance of International Peace and Security. So linking it then to the breakdown of rule of law in these countries now has something to do with larger breakdown of international peace and security. Hence, the justification for bringing in international adjudicative bodies into this situation, like International Criminal Court. And those recommendations that were debated started to morph into some more concrete terms and resemble many of the mandates and programs that we now see being implemented in the field today. So, a particular note in relevance to my talk today, some of the recommendations included increased importance to the promotion of justice and rule of law, and this refers to all places that I'm talking about. This is sort of a general one. Emphasis on the importance of rule of law activities in peace building. It's like Bosnia, Iraq, to some extent Afghanistan, but I think another one of the recommendations applies more specifically to Afghanistan, so I didn't put it in that. Support for the establishment of a rule of law unit within the UN Secretariat. That's all places. So out of that flows all the rule of law activities, and now everybody has a rule of law officer, and they do rule of law stuff in various incarnations, and now a couple of recommendations that emphasize the issues of transitional justice, including emphasizing the responsibility of states to comply with obligations to end impunity and consideration of sanctions as an important tool in the maintenance and restoration of international peace and security. Sudan as a really good example of that. And there was also a specific reference which I thought was very interesting, and which I'm sure Mark is well aware of, and maybe others who've worked in this area, and I met Richard Barrett the other day. The 1287 Sanctions Committee for the Taliban and Al-Qaeda should continue its work on guidelines, including listing and delisting procedures. So that's a little committee that's been created within this whole body of rule of law to list people whom are suspected to be Taliban or Al-Qaeda, both, either both or either, and delist them in accordance to whether they become less dangerous or not a threat anymore, etc. Nobody's been removed from this list so far. I thought that was interesting, and I'm not really going to focus on this. This lecture is a very specific body, but it's quite interesting that that's sort of rolled up into rule of law generally, because in fact the debate on whether rule of law should be even a tool of the international community's repertoire to go into other countries started with countries like Burundi, Sierra Leone, not with Afghanistan. So it's kind of interesting how it all got tacked on, but that's a paper. So all of these debates culminated, as I said, in this December 14th report. Just to go on December 14th, 2006, using all these previous recommendations, these debates, this discussion, all these countries are breaking down more than what I've got up here. I mean, they were, as I said, started with the African countries and moved into to the variety that's up here. The concrete outcomes in terms of what kinds of issues should be dealt with under the guise of this rule of law umbrella turned out to be, as examples, and there was an office formed within the UN Secretariat called the Office for Rule of Law and Security Institutions. It is administrated by the UN Peacekeeping Mission, so it's under the UN Secretariat, but it's administrated by the UNDPKO. And it's meant to cover issues such like, and this is where we get to now these specific examples, police, judiciary, legal infrastructure, correctional units, mine action, DDR, which is demobilizing, I can't remember all the demobilizing, disarmament, reintegration, which is, you know, formally fighting forces being sort of reintegrated into the community after being stripped of their weapons and given a new sort of role in a peaceful society. And security sector reform, which is a huge term which we're still defining and trying to figure out what it means. But so these then became the actual activities that we do. And so that then leads to the kind of experiences I've had in these countries, because I am a child of these activities and doing these activities which were being, discussed in these debates. Having said that, there's no way, as Mark sort of talked about my background in CV, I actually came after this. I was doing this before, but as what happens with the international community development of policy and programs, people are doing these things, and then the UN and other bodies catch up with what is actually going on, and then they do a debate on it, and it all becomes policy. So just keep in mind, I didn't just start doing this from 2006, but just it's really good that the international community has recognized it. Not good that they didn't realize some of the pitfalls of taking on such a huge responsibility. So as I said, the developments that I've talked about, what's garnered more, I guess, international attention, and something I won't talk about this much in this talk, I'll just give a couple examples, are the areas of transitional justice and sanctions. Those recommendations I mentioned, which refer to, the international community making some judgment on how that country should deal with war crimes, violations of humanitarian law during conflict, and or dealing with leaders of these movements, either in an international or even a national judicial context. So in Bosnia, they did it through the International Criminal Tribunal for Yugoslavia. In other countries, they've done national tribunals. There's been regional tribunals in Africa. and sanctions, which you've heard in various incarnations in Sudan. You also hear it in Iran, which obviously I'm not talking about, but I mean that is a tool for used as leverage against a country to make them adhere to some sense of rule of law. So while it seems that's gained a lot of attention, I've been working in the one that's been given less attention in the area of rule of law, as Mark said, which is the development of legal infrastructure, judicial institutions, and the building of a culture of rule of law on the ground. So you can do all this stuff at the higher level. You can deal with past crimes, you can have people reconcile, which are great things, and they should continue. But if you don't develop the legal infrastructure and the culture of rule of law or the culture of justice, which matches the cultures of those countries that you're in, that's not going to be sustainable. It will deal, obviously, with the immediate consequences and crimes that happen, but it may not sustain itself. And that's where I get concerned and where I've been involved. Not so famous, but really important to the people in those countries. And so in my view, what I've witnessed in places like Bosnia, for example, where there's a huge and wonderful initiative, which I was involved in bringing leaders of the ethnic cleansing to the tribunal, what followed afterwards in terms of how that connected with the national judicial structures on the ground left me thinking that actually the international community's involvement to the local population appeared incoherent and uncoordinated, and sometimes inappropriate. I don't know if you remember, I mean, during that time of the Bosnia conflict, I mean, when I was there, we had, certain populations thinking that they were being targeted not for violations of humanitarian law per se, but for political reasons. And this is also happening in Sudan. And that's maybe wrong. I'm not here to sort of say I sit on one side or the other at all. So I'm going to say both sides. Just keep in mind that I'm undecided, but we were perceived as being political, we the international community, because we weren't clear. That's the most important thing. And I contend this area of rule of law development, as I'm calling it, and the fact that institutional and infrastructural development has suffered is because there's really a lack of agreement among international community, and this really comes back to donors as well, on how far we need to go in terms of developing these long-term structures in these countries, in investing, how much we should invest in the people and their local institutions versus how much we should invest in what is left from maybe the formal institutions that were there that may have been brought by a previous colonial power even. And there's a lack of agreement. There's also a lack of agreement in terms of what we can offer them. So different countries offer different things. Now, when you look at it from the outside, it tends to appear pretty simple that we're able to offer training to legal professionals, police professionals, prison officials. We're able to offer legal materials. We're able to offer some, as we do, we write all sorts of laws for these countries. We offer many things. But I do believe there has not been a proper, comprehensive, and much needed debate on what we really can offer to these countries that they can use and that will sustain their development. And before, so I'll give a lot of war stories after this, but I do want to set the stage for what I'm talking about, because I'm not the first person, as you have maybe mentioned, that there's not many people doing it. There's a body of academic inquiry that I have found very interesting in my work, which I think applies at least partially to what I'm doing. And that has to do with the law and development field. There is such a field called law and development, and legal development theorists who mainly look at economics as the key leverage point within this area, have looked at issues of, which I'm leading up to talking to, transplantation of Western legal models into non-Western societies. And that has really been, according to the law and development theorists, mostly from the neocultural sort of phase of legal development, but even before, the assumption that us bringing in a Western legal model into a non-Western society is the best thing we can do for that country, and it can lead them to develop a stable, structured society that's based on rule of law, and that it's a very effective way to rehabilitate a destroyed legal system. So, as Mark alluded to, there are countries which may still have some functioning legal mechanisms, whether they're formal or informal. That's another nuance. Yet we still mainly operate as if there's nothing there, and transplant something that was familiar to us. And it's familiar to us because we live in countries that are Western, that are within which Western legal models are used. And we transplant things we know instead of things they may need. We actually get caught up in, I know how to train people on human rights, therefore that's what they need. And I'm not kidding you, this is exactly how simplistic it's become. And the example of this failure has been most notably realized in Afghanistan, although there are many other countries. And I wrote an op-ed about this a few months ago. Seems like a long time ago, but I think it was just March. In the Globe and Mail, in which I basically said that there has been a waste of billions of dollars. I think it's also on the talk intro. Trying to transplant what we think is justice into Afghanistan, and which has been virtually, ignored and not accepted in that country. Not because they're not, people in Afghanistan do not believe in human rights, but because they don't understand the system. There's a huge disconnect, let me put it that way, between what can be brought into their system to bolster what they have, what can mesh with values that are very strong to them, and what also fulfills the need for an international standard of democracy, which we all believe in. So there's no attempt to bring that together. There's an attempt to build a structure and try and push people into it. Now, related back to this theory, the sort of main architects of this legal development theory, this transplantation model, are David Trebek, Mark Galanter. Mark Galanter has done a lot of work on local traditional justice in India. David Trebek, who's at University of Wisconsin, I met him the other day, has done a lot of work on law and development, mainly though looking at the motivation. Why does the international community even care about developing legal institutions in these countries? And he and most of the people who follow his train of his area of his theories believe that it's the international community or the Western nations need to ensure that there is economic stability in those countries. Therefore, they're not going to destabilize the rest of the global economic system. And the way to do that is to give them structured legal institutional systems. Therefore, they're not going to mess up the balance of powers in the world. I see it a bit differently, but I wanted to give you what's the official, the accepted theory which is being written about. It's mainly his theory fits well with programs that are implemented by the World Bank or the IMF, because obviously the key to stabilizing these countries that have been in conflict, in their view, is to stabilize their economy, and therefore then they grow from there. And as I said, the World Bank now has become, sort of the recognized leader in terms of law and development and stability. Now, other than the economic indicators, my interest and what I've actually seen in the field focuses on other indicators, for example, like social, political, and justice indicators that I consider as more relevant in some cases, but seem to be subordinate in this analysis. And I understand why. Because globally, global actors are much more concerned with the bottom line, money, than with whether people are happy or not with a particular, way of doing justice or law. Whether there's a legal clinic or a courthouse, who cares? As long as, everybody's able to be prosperous, they'll be happy. I think it's a little more complicated than that. And while I'm not disputing the fact that the economic factor might be the first and most important factor to stabilize, I do think the other things need to follow. And as I said, in my experience, the economic factor has either been less important or almost irrelevant in the developments that these countries have gone through. So I actually have seen a breakdown of a system we have even put in place, even when countries are prospering. Although, when it's analyzed, when academics like us go back, we actually really start looking at poverty factors and using that as the way to indicate that this society is not going to be able to develop any further in terms of justice and rule of law because everybody's poor and they don't have access to things. In Afghanistan, it has been shown to be completely the opposite. In a situation where people have nothing, they still have the tribal leader, and he still adjudicates disputes, and they still get solved, and people are still content. So I'm researching this area. I don't have any conclusions right now, but to me there's a disconnect. So as I said, I think it's been more, there's been more, it's more the social cohesion or lack thereof, political acceptance or rejection, or judicial substance and culture that's been much more of a defining factor in looking at the success and failure of rule of law and justice in these countries. As I said, the use of economics has resulted in a one-way analysis, and I'm trying to open it up a bit more by giving you some examples. So in Bosnia, as we know, and were you in Bosnia? You were in Kosovo? Or? Yeah. So in Bosnia, and this was a lot in the media, and by now in Canada we have a lot of Bosnian friends who talk about those times during the war. But I think it's an important conflict because it's the first time that the international community really cohesively came together to try and look at comprehensively rebuilding institutions in a country. And there was a lot of focus on justice and law, especially with respect to property rights. Again, getting back to the economics, but at the same time, that's what makes the world go round. So if it brings donor dollars in, and if it makes people feel comfortable to have their property back and leads to stability, we go with that. But for Bosnia, the example I'm going to use right now focuses more on the area of sanctions and obligations of states to comply with obligations to end impunity. In our intervention in Bosnia, the international community set as its standard for Bosnia, and also, by the way, for Khartoum, the Sudanese government, with respect to its involvement in Darfur, for it to prove that it was on its way to stability and rule of law. They had to prove to us that they were dealing appropriately with crimes against humanity and genocide in either case. And in Bosnia, we're talking about the time between 1992 and 1995, although arguably there were crimes that happened before and after these dates. But we set a specific date for the International Criminal Tribunal for the former Yugoslavia to deal with war crimes. And with Sudan, it's ongoing, with the threat that should these states not deal with these issues of crimes against humanity and genocide, that they would be subject to international scrutiny and examined under the international criminal regime. And in both cases, this happened. As I said, the International Criminal Tribunal for the former Yugoslavia, and in Sudan, the president and some cohorts, the Minister of Humanitarian Affairs, became Minister of Interior, were indicted under the International Criminal Court. And that did not in any way impact stability, rule of law, and justice in those countries. With Sudan, it's definitely still clear that and I'm not talking about southern Sudan, just to be clear. Southern Sudan is a different case that I'm going to talk about later. But in the north, in Darfur, there are still violations going on, even though we used one of the tools which was developed and which was accepted by the UN Security Council through the Secretariat, at establishing a rule of law through pressure that international sanctions and international, sort of pressure that you need to, you cannot have a culture of impunity. Those countries still go on and do not adhere to what our definition of rule of law is. So I don't know if that tool is so effective. What does that mean about how valuable it is to the repertoire of tools we have in our rule of law toolkit? I don't know yet, but I think it's being discussed and examined. And with Bosnia, it could be argued, and I am up for that debate with people who feel that Bosnia is stabilized. However, I know from my work at NATO, which was my last post before the Harvard stuff, it is firmly believed within Bosnia, within this sort of milieu, that should the international community's presence, which is mostly now there in the form of NATO, doing development with the military, should leave, there's still a feeling, whether it's a fear or whether it's a reality, because I've been in Bosnia for a few years now, that there would be a descent into chaos again, a sort of breaking of the rule of law there. So again, what does that mean, about what we've done in Bosnia in terms of trying to stabilize that country using those threats? I don't know. I mean, maybe for me, when I look at the work I did in Bosnia, which mainly had to do with helping people return to areas which they had been ethnically cleansed from and regain their property, and we tried to help them do it through the local and formal court system there. More often than not, that system didn't function, yet there was barely any attempts from the international community side to work with that court system to help improve it and its efficiency, to the extent that we allocated resources to sanctioning people who were war criminals and building a huge international criminal court. Again, I get back to my, my hypotheses that I'm throwing around here today. Thank you for being my guinea pigs about, this incoherent and lack of cohesion in what messages we send. Now, in the short term, I would agree that international sanctions in this area works, but in the long term, in terms of sustaining and developing a culture of rule of law in these countries, in terms of developing a situation where ethnic groups really feel like things have been resolved and reconciled, I'm not sure. And I remember, this is all, sort of informal talk among international development lawyers in the field. We were always in Bosnia saying, probably the only way is Truth and Reconciliation Commission, like in South Africa. I worked in South Africa in 1994. Now, of course, we're now talking about how that didn't even work to the extent that we hoped it was. But in many cases, the lack of a reconciliation aspect that is born out of the grassroots, I think, is a really critical factor that we miss out many, many times. And now we're discussing that in Afghanistan. We're discussing whether we need to go back, 8 years later and bring people into the process of political negotiations and reconciliation from elements that we previously exiled from the accepted group of democratic leaders in Afghanistan. We're doing it after the fact, which is proving to be a bit of a problem and is controversial. But at the same time, we also are showing that we really didn't believe in what we were doing in the beginning anyway. So, we again appear lack of cohesion, lack of coherency. And so, I say all of this criticism by way not to just to sit on my pedestal and criticize, but to say, I think a lot more thinking needs to be done, because I think we're all smart. The international community and the national states that we're involved in are all really smart and committed, and there are ways to do this. And so I would just like people to start doing that instead of just continuing on the train of let's do the same thing over and over again. So with sanctions and as I said, trying to inculcate a culture of impunity, we've really fallen short, and I think we know that to some extent. Talked about Sudan. Skip that. And again, I'm happy to do questions on this as well. Now, I think this focus, as I said, on this area, sanctions, culture of impunity, etc., has really we've really fallen short on the intellectual thought. We haven't put much intellectual thought into how we stabilize whether it's formal and informal institutions in these countries, as I have spent a lot of time in that, and I barely am able to get anyone to listen to anything more than, okay, have you solved these many amount of legal cases in this area? Have you helped these many people return? But when I want to start talking about what that means for the long-term development of legal stability in that country, money's gone. It's, okay, we're done now. You know, they're kind of functioning. And this is where I get very sad and where I'm still hanging around in these academic institutions trying to find money to do that research, because I think it's crucial to figure out what works for those countries. And it may just be sitting right under our nose, as Mark alluded to in Afghanistan. I'll talk about at the end. The area that I've been engaged with mostly throughout my work in terms of rule of law and justice sector development has been the development of, I mentioned this op-ed, let's see. How can we put it? I mean, I guess I just have to list it. Legal infrastructure, legal institution building, legislative development, filtered on top of that, issues like access to justice, human rights, capacity building, all those areas which we have, and I'm mentioning phrases that are within the international community's strategies and policies to work in Afghanistan, Iraq, Bosnia and Sudan. And I know this because every time I interviewed for a position to go to these countries, and I'm not kidding you, all I had to do was replace the word Iraq with Sudan, but the rest of the interview went the same way. It's the same institutions that are being recreated and reinvented in each country, pretty much the same way. Now, I didn't do that. I'm hoping that I was a little more nuanced when I got in the field, but sometimes you're restricted by policy. And policy is important, and standards are important, and strategy is important. It's very important for large institutions and agencies to understand that there is a model upon which they're working. But we do have to be careful that we don't engage local nuances, differences, mechanisms, histories, wishes for the future in these countries. And there's where we fall a bit short. I'm skipping over lots of stuff because... So let's go to Afghanistan for a minute. In Afghanistan, it's very well reported how underdeveloped the court infrastructure is. Still. Yet, I think I can tell you, and I know Mark could tell you, probably give you some figures, because I don't ever remember numbers. We have spent most of the budget of judicial justice sector development money on building infrastructure in these countries. So it's like rehabilitating courts and police stations and equipping these people to do particular things. If it's a judge or law schools, it's legal materials, and if it's police, it's equipping them with guns and backpacks and stuff like that, and also building the police stations. That is not going to do anything to, if these people with the tools that they have, the infrastructure, they have a nice building, they have a computer, they even have a car, which doesn't, actually we don't usually give money for that. Unless they feel that the law, the tools of law and the programs that they have to implement the access they have to the population does not mean anything to them, they're just going to be sitting in their offices. They're not actually going to be doing anything to spread community policing, to ensure access to justice, implement human rights. I think one step we've made in Afghanistan, which is positive, is that everybody knows those terms. Everybody understands they're important. People are trying to learn them, Because there's been sort of two outcomes to this, I think, throwing money into a system that we haven't really fully understood. One outcome is that there's a whole bunch of beneficiaries, for lack of a better word, whether it's the police, judges, the community, local people, who say, well, this is the money we're going to get for a computer, for a courthouse, for a local legal aid agency, so that's what we want. We're going to get money for that, that's what we're going to ask for, without thinking whether that's what they really need in the community. And the other outcome has been, we don't want any part of that system. We still want to do our own thing, which, since it is unknown to the international community, what tends to happen is we demonize it in some way. So it's a tribal structure, it doesn't have any value, or they cut people's heads off, and, you know, we make up all these sort of myths based on some real incidents here and there that define that whole thing. What two of those things mean is that we have absolutely no footing upon which to build anything in that country at this point, even with all the money. So then the equation goes, we just keep spending billions. I just always wonder, and I think it's pretty funny, that it took us so long to figure out, I mean, we didn't even ask where the money's going, which is kind of funny. And then they're corrupt, and, you know. And now, you know, the latest incarnation of the corruption debate in Afghanistan, which happened in Iraq, happening in Sudan and Bosnia, was, first it was that, you know, Afghans or powerful leaders, political people are taking the money. Now it's, and they're giving it to the international community, who has corrupt elements too, right? So private companies, international agencies, we're getting pulled up in the whole thing, whether it's true or not. Again, I'm not making a statement saying it's true or not. I'm saying the system is creating all of these myths that are getting perpetuated. All the while, legal development, rule of law, justice, this huge confusing concept, which we don't even want to take the time to define and use examples from these countries, gets lost. In terms of Sudan, I thought that was an interesting example to talk about, because Southern Sudan, because we rarely talk about it. And I don't know, you have people who work in CGO in Sudan. And I worked on a project in Sudan. I thought it would be interesting to tell you about it, because I thought this was a perfect example in a post-conflict setting. So Southern Sudan had was essentially considered in transition, in peace. And I was called in to work with the judiciary and the Ministry of Legal Affairs and Constitutional Development, which is a ministry in Southern Sudan akin to what would be a Ministry of Justice, but because Southern Sudan does not have independence yet, it names its ministries different things, and it's still under the Khartoum government. So it's called something different, but it's essentially like a Ministry of Justice, to work with them to develop legal education and training. How was the question from them, and they wanted to build legal training institutes or law school. They wanted to revive the old law school from the University of Khartoum. They wanted to do a variety of things because they felt that, which is kind of backwards, but okay, I mean, this was our doing. Southern Sudan was on its way to independence. The government had been elected somehow. Political institutions were being established, and nobody knew what was the commonly used law in that country or that region as of 2000 and, I guess we started the project about 2005, but by the time I went to Sudan it was 2007. It was still being discussed by the judiciary of Southern Sudan, the Supreme Court of Southern Sudan, and the Ministry of Legal Affairs as to what were the sources of law which would be used in the courts, even in local mechanisms. Because Southern Sudan, and Sudan being a post-colonial state, had, you know, very many layers of legal sources that it used. Common law, of course, and Sharia law, because obviously when it was, you know, part of the, you know, Republic of Sudan, Sharia law was imposed as the main law. And then there was, I don't know, again, how much is known in the audience about Southern Sudan. It has the biggest diversity of tribal groups in any African country. It's also the largest African country, so customary law. And so I was sent there to try and figure out how to build a legal training and education regime, again, whether it's through law school, whether it's through an institute, or whether it's just through developing policy or empowering the existing institutions, based on a set of laws which they would all agree upon. So that's post-conflict rule of law. Post facto, the state being stood up, and political institutions functioning. So, I mean, we can go into the ins and outs about, I got really into obviously discussing what were the value of customary law versus common law versus Sharia law. I'm a lawyer, I love talking about that, but it was so very interesting that that wasn't considered a priority. What was considered a priority, and did happen, was establishing a Supreme Court of Southern Sudan. So Sudan is a country, South Sudan wants its independence, a number of institutions get stood up in South Sudan, as I explained, some ministries which are sort of still under the main ministries in Khartoum, call different names, but the aim is that they will become the ministries when Southern Sudan gets independent. The only institution which was stood up as a fully functioning independent institution right off the bat was the Supreme Court of Southern Sudan. And that was considered to be tick mark rule of law in Southern Sudan. We've got it now. So you had these judges, former SPLA fighters, Sudan People Liberation Army fighters, who were lawyers. I mean, they were trained lawyers. It's not like they were just, military guys. But the most interesting part about that discussion was it was less about discussing law, but it was more about discussing what happened in the past and how they resolved conflicts and how, I was his commander, therefore I can push him to do this and that, rather than actually looking at customary law and different laws. Then, of course, once people like me went in there, a whole plethora of international organizations came in to try and flesh out what is customary law, what value can Sharia law have in that place in the future of Southern Sudan, which will have a majority of Christians and a minority of Muslims. Should it play a part and all that kind of stuff? But again, post facto. So that's an example of how we do it backwards. We're doing the same in Afghanistan now. We're now looking at, it's the new fashion, to look at informal justice. And let me just see if time. Yep, okay. So what I'm going to do is informal justice. Hope I'm doing this right. There we go. So I just got 3 pictures. I didn't want to sort of bore you with my talk. And so now what's happened in the international community? Mark said he met me when I was doing this, which was a long time ago. And I'm doing this at the grassroots level a long time ago, and it's been going on for centuries in Afghanistan. Yet, believe me, it has only been given maybe a sentence or 2 in all of our policy debates and documents, maybe since 2005, maybe. I'm being generous. And now it's what do we call it? The panacea. That's the word now in the US policy. I'm in Harvard now, so I've got all these great terms that get told to me all the time by US policymakers. It's the panacea. How we're going to solve the lack of rule of law and instability in Afghanistan. We are now, and I'm not debating it. I actually think the informal justice, as Mark said, I worked with tribal leaders. I worked with resolving community disputes over land, family, everyday issues, larger political issues. In fact, the largest, let's say, conflict, which was sort of coming together to develop the constitution in Afghanistan, was done through this kind of mechanism, which is called the jirga, and it was called the Loya jirga. It was the constitutional jirga, the biggest jirga. This is the way Afghans resolve conflicts. And we knew that in 2001. Yet there was absolutely no attempt to inculcate this idea into our thinking about developing justice and rule of law in Afghanistan. I mean, to repeat it, to even take myself seriously, because every single dollar that has been allocated by every government, and Canadians jumped on the bandwagon later, in fact. Canadians were previously quite good in this. We were previously, before, when we were there in the mid-2000s, thinking of doing a lot of things through local institutions and through government institutions, which had we continued that way, we probably would have discovered this a little bit earlier. But anyway, the international community now goes as a basket, and they sort of have try to have a coherent message in those countries. So sometimes it becomes lowest common denominator. We do what the least committed country wants to do. But we have allocated billions of dollars to building courthouses in Afghanistan, which people don't use. 80% of Afghan people use these to resolve their everyday conflicts, which they're happy to do. So I'm generalizing. There are obviously cases in which using an informal mechanism can cause a negative impact on one of the complainant, or even the accused in the case. And mainly people bring this up with respect to women's issues and family issues. And I'm happy to have a more in-depth discussion on informal justice another time, because that's my area. What I've actually discovered with informal justice, especially as it's implemented in the South and the Southeast, where I've been doing my recent research in Kandahar, Paktia, and Khost, which is that the victim in these cases actually has the most rights. So when the victim's a woman, she has the most rights. When the victim's a man, he has the most rights. So in cases of adultery, both the man and women are accused in this case. So that's why we hear of the outcomes of these informal justice, these jirgas, when there's an adultery issue involved, where women get stoned, and because they're actually considered in that case an accused, because when an adulterous situation happens, both the male and the female who are involved in the adultery are considered culpable. So that's just a nuance that people don't hear about. They just see the larger thing. But having said all that, to resolve everyday issues, this case was, I was, involved in many of these, was a Kalashnikov deal gone bad. No, I was not in Afghanistan during the Soviet times, but this conflict, this case had been going on since that time. Gone through family generations. So his father and this other guy's this guy's grandfather and this guy's father were debating whether money had been exchanged for Kalashnikovs that should have been given, how many Kalashnikovs, and was the right money given. And the family conflict had gone on and on. Each generation had taken on the conflict. And in the meantime, other disputes had arisen over it, which is that in order to resolve it, one generation above, one of the families had married their daughter into that family, and then she got abused, and so then another case got brought, and it becomes this nightmare scenario. And it's a tiny village. This was like a village of 20 people kind of thing. I mean, a little bit more, but really not that much more. Finally I get to Afghanistan, and in 2000, and maybe this was 2005, I'm sitting there. I mean, I actually took the photo. And I'm just saying, how can we solve this? And the way it was solved essentially was both of them had finally agreed that there was one guy, Omar, whom they both could trust, who could clarify a particular point that they were still debating. This Omar. That's what they agreed upon. So then in a jirga, it's really, once an agreement on something is reached, you go from there, and then you start making other agreements. And so the Omar guy, this fellow, was in Pakistan. So this was an issue because he was a refugee. He couldn't come back, or he didn't have the financial resources to come back. So what I did was brought the guy back into the jirga. Once they both heard what he had to say, he clarified the issue, and they signed a piece of paper. As you can see, my staff is preparing the piece of paper, and they did it. And this village has never thought about this again. Very simple. We don't need $1 billion for that. What we need is actually an understanding of how that can fit into the mindset that we have about justice and rule of law. And there are ways to do that. And now is the crucial time. Now I guess that it's been acknowledged by the international community that informal mechanisms, community practices, you know, are important and useful. The challenge for us is to try and figure out how they can be structured in a way that makes us feel that they're sustainable, that they will be able to deal with all disputes. It's interesting because if you look at models in, for example, the Gulf countries, in, you know, in Bahrain and in Emirates, they have actually, it's very interesting, for years and years resolved commercial disputes this way. I mean, not sitting on a mud floor in Afghanistan, sitting in a boardroom, but still, discussion. And in fact, I don't know if you paid attention to this development, which I thought was really interesting. In order for the international financial companies to feel comfortable investing in Dubai, they actually asked Dubai to set up a commercial court for their own comfort, for the international companies' comfort, that disputes that arose over financial issues would be resolved in a form that they felt comfortable with. To the emirs in Dubai, they keep resolving it the way they were resolving it. But in order to enter the global picture now, you're now sometimes meant to establish these kind of mechanisms. Again, I'm not making a judgment, I'm just wondering, you know, we're going in a direction. So if that's the direction, what can we do in a country like Afghanistan? What can we do in a country like Sudan, which has 40+ tribal groups, all of which have customary practices, all of which have, customary practices vary in practice, but don't vary in value that much. And I haven't talked much about Iraq, but in Iraq we completely ignored local tribal practices. They were only used on an emergency basis by international, multinational forces to resolve issues in insecure areas, and then was just left to die as if it never existed. Having said that, Iraq was more comfortable with formal institutions, having had a longer history of intervention by colonial powers, and was more happy to bolster their judicial system. But in countries like Afghanistan and Sudan, we have huge challenges ahead of us in terms of trying to mesh these two ideas. And I still don't have any answers, except for, which I found the saying, it's right there. I was like, what is that PowerPoint? So thinking globally, acting locally. And David Trebek, so he's kind of the guy who I work under quite a bit now. He wrote an article talking about law and development and how we can move away from this strict economic analysis to looking at more issues. And the title of his article was Scan Globally, Reform Locally, the Horizontal Learning Method in Law and Development. And that's a starting point for me. So that's sort of the area now I'm involved in research, and CG's already on the way because that's their slogan, so they already are doing it. So, you know, I do think we need to think more theoretically, and I'm not saying this just because I'm in academia now. I actually think that it's been a huge benefit for me for sure, but I think for others, to hear from someone who's been in the field, to see the gaps, and try and figure out how we can sort of develop, you know, operate in these countries, bringing what we can to these countries in terms of stabilizing, developing rule of law, justice, using the tools we have, but also matching it with what's there. And that's been the biggest challenge. So I hope I wasn't too broad, but thank you very much. I don't think that they're stonewalling, but I think that the World Bank is very much enveloped in the system that it has for determining stability in countries, right? And there's been a lot of criticism of that, right? And so therefore they find it very difficult to think about other ways to measure success in rule of law and development, which could be like cultural cohesion, like I said, or, you know, acceptance of particular ideas. And so they've made it very, very clear that it's economic. So in that sense, they actually even apply, they expect that if everybody has a certain feeling of wealth and, you know, economic success, that they'll somehow feel included in society and its development. And we know that's not true. We know that the elites still, you know, sort of hoard the money and implement programs which people don't really still have access to. So it's a flawed, it's a too narrow for me. That's really my criticism.
Well, you mentioned that you thought the international community's approach to implementing rule of law processes was rather disjointed and a lot of money was spent on infrastructure. But I'd like you to comment on Canada's contribution to rule of law, because my sense is, from my readings, is that Canada has invested a lot of time, effort, and energy with rule of law issues, both in the Balkans, in Haiti, in Afghanistan, Iraq, Sudan. Mm-hmm. And my sense was that this was not all for infrastructure. It's been government policy for quite some time, and I'm not in the government, but just from my readings, that this has been a key focus area for our international efforts. So are you lumping Canada in with the international community? And if so, what should Canada be doing that it isn't doing in this area?
So first of all, I am not at all debating that any of the international community, including Canada, has not had it in their policy to do this. They have. My criticism is more about not doing it in a way that will ensure sustained success. So again, saying in your policy that you would like to ensure the development of rule of law, through building legal infrastructure, through the other things that Canada is, you know, and other countries are very much committed to, capacity building, is all good if you understand how to do those things to make them sustainable for that country. The example of Afghanistan, what I was giving you, was meant to show that we think that the development of rule of law means however many courthouses we've built. I'm being very simplistic here. There's much more complexity to it. Or how many training sessions we've done. Now, with our, again, discovery that informal justice or tribal jirgas are an important aspect, how many human rights trainings we do with tribal leaders. If we count those up and we do 100 of those, then we have successfully met our commitment to rule of law. Maybe we have. But have we really affected the judicial landscape of Afghanistan? Have we really made Afghans feel like they have more access to justice? That's where I have my debate. So what I am trying to encourage the international community to do is to spend a little more time finding out what they really mean by development of rule of law, so that then they can implement the right level of programming, so that they can use their money to have more of an effect. So for example, when the PRT in Kandahar has a rule of law officer who's sent there by DFATE, and she or he calls me each time, and we develop each of the, she or he has a very limited, well, they're limited in where they can go, but they're also limited in what kind of things they can provide training for. And very often we end up in a bit of a debate about, well, if you're going to just be able to hand them out copies of the Universal Declaration of Human Rights, that's not really going to help them understand how the local tribal laws will mesh with human rights values, or how they'll be able to utilize it in his community. Why don't you bring a local facilitator in to do this and that? That's where we get lazy. So it's not meant to say we don't maybe have enough money allocated to, but are we doing it correctly? Does that answer your question? And all of us, and as I said, Canada started with a really good approach in Afghanistan, in my view. This is prior to our moving down to Kandahar, because I was in Afghanistan before, when the Canadians were in Kabul and doing more peacekeeping stuff, and after. And in the before stage, I felt that we had a much broader scope to develop rule of law and justice, because we weren't in a opposition sort of a dynamic with Afghans, you know? And now we're a bit troubled because of that.
There was another hand up over here. Is that you? Okay. There's a microphone here.
Really,
this is a bit more of a comment than it is a question. And a lot of the information you gave is quite helpful to me. I'm a placement student right now with Community Justice Initiatives, which is a restorative justice organization here in Kitchener. And I'm working right now on developing an approach to programming for the area of the DR Congo with respect to gender-based violence. But a lot of what you speak to is so relevant because we have to look at I believe we have to look at what this means to people on the ground. And what I realize in what I do here too are victim offender reconciliations. I work with male sexual offenders and peer group facilitation. And what gets missed, and what makes, I find, this approach so effective, what gets missed is the body of knowledge of the participants in the conflict. And we don't mine that body of knowledge. We don't bring that into the process. And when we facilitate a dialogue with what they need, with what they want, and they create the outcomes, then the investment is there, and you're on a better path to sustainability and adhering to being more peaceful, not necessarily the rule of law, but just having a bit more stability and peace in your own personal life, which I think also needs to be taken into account when we're talking about legal theory, legal infrastructure.
Yeah, exactly. And you know, I know that was the motivation when the Security Council defined its factors that would sort of make up the rule of law intervention. They put peace building in there, peace building commission, and by that they meant to realize that it's a much broader concept. And so you're exactly right. But again, it comes back to me, my critique is that do we spend enough time actually fleshing that out so that we understand where we should spend our money best? That's one thing. The other thing about restorative justice and looking at the local body of knowledge, I mean, the perfect example in the African context, which you know, probably provides more relevance to DRC, is where you work, is Rwanda, of course. And in that context, and we've also done it in Afghanistan, we did find what we called a local mechanism that we felt that also the Rwandans identified as a mechanism to provide restorative justice that would make them feel comfortable, like the Gacaca courts as an example. But then we international community defaulted into our comfort position, which is that's the panacea for everything. So now the only restorative informal justice mechanism used in Rwanda is the Gacaca courts, which has a lot of holes itself. So I also warn against that in Afghanistan, that you cannot only hand everything over to tribal jirgas. And when it comes to gender-based violence in these places, it's really interesting because there is that idea that violence against women is unacceptable, and it is. And at the same time, the local community deals with it, and because it's unknown to us as to how the outcome is going to be for the woman, we're scared of it. And so that's where more discussion needs to happen.
Yeah, I agree too. It's that fear and that lack of trust in people's own, and that's where I think we need to go a little bit more, is how do we develop the capacity to be around trusting others, trusting ourselves, and letting that process unfold as well too. Because I agree with you too that one model doesn't necessarily apply even in the same communities, especially when new issues arise. But if we go into those bodies of knowledge and let people speak, there's creative outcomes that we might not even consider that are applicable and meaningful.
That's right.